A very good morning to all my dear students. Today we are going to discuss about a new topic, that is execution of decree. Before starting with the same, I just recapitulate certain important points as they are necessary for the starting of today's topic, that is execution of decree. As you all are aware that there are certain important steps for instituting a suit in a court of law, and these are filing of the plaint, and thereafter once the same is registered in the court of law, it will get converted into a civil suit, and thereafter on being admitted as a civil suit, the court may give notice to the other side to put an appearance before it, and also to give him an opportunity of being heard, and the document by which the whole process is to be done, that document is known as summons. And after summons has been received by the defendant, the law imposes a duty on him to file his written statement in the civil suit. As you all are aware, that written statement is nothing but a reply to the plaint. And once this reply has been taken on record, the court may give another opportunity of giving right to the plaintiff to file its reply to the plaint, and that reply is known as replication. And once the replication has been taken on record, the court may look into the averments of both the parties in their respective pleadings, and thereafter frame an issue in the civil suit. After the framing of the issues, the court may fix the matter for plaintiff evidence as well as for defendant evidence. As you all are aware that plaintiff's evidence includes three types of stages, such as it includes examination in chief, wherein the plaintiff examines his own witness in the court, and thereafter an opportunity of being heard or to cross-examine the witness of the plaintiff by the defendant, and that stage is known as cross-examination of the witness, that is the plaintiff's witness. Once the cross-examination has been completed, and if the witness has been won over by the defendant, then in that case, the plaintiff, with the permission of the court, may re-examine on the facts which have come to his knowledge during cross-examination. And once all witnesses examination, cross-examination is completed, thereafter the matter would be fixed for defendant evidence, and it includes the same three stages as I have mentioned under the plaintiff evidence. But the difference is that in place of plaintiff witness, it is the defendant witness. And in case of the cross-examination, it is the cross-examination is to be done by the plaintiff's counsel to the defendant witness. And thereafter, the matter or the case would be fixed for arguments, and it has been divided into two stages, that is oral arguments and written arguments. And once after taking into consideration the oral arguments as well as the written arguments, the court may pronounce an order in the case, and that would be again be consisted or divided into three parts, that is order, judgment and decree. And once this judgment and decree has been passed, then the person who has won the case, that person is known as decree holder, and the person who loses this case is known as judgment debtor. Therefore, if the plaintiff win this civil suit, then the plaintiff status would be converted into decree holder, and that of defendant would be converted into a case of judgment debtor. Now, what comes next after this? After this, the court or the party who has won over the case may not get the relief satisfied from the defendant, even after the judgment has been passed in his favor. Then, in this case, the decree holder or the plaintiff, as the case may be, apply to the same court, that is the trial court, for enforcing its decree, and thereby to give the fruits which has been incurred in his favor. And this stage is known as the stage of execution, and that is we are going to discuss today in this topic, that is execution of a decree. Now, I would like to start with the same. As far as the word execution is concerned, it has not been defined in CPC. As you all are aware that there are various expressions which has been defined in section 2 of the Code of Civil Procedure, but the word execution has not been defined. Now, in literal sense, the word execution means, or we may say that it is the enforcement of a decree by judicial process which enables the decree holder to release the fruits of the decree passed by the competent court in his favor. As far as the provisions regarding the execution are concerned, it has been given from section 36 to 74 of Code of Civil Procedure, and it contains the rules in the orders, and this is the one of the lengthiest order in the CPC. It is order number 21 and it contains 106 rules. So, how can these proceedings be initiated in the court of law? These proceedings can be commenced with the filing of an application. And where to file this application? The application can either be made to the court which passed the decree, or where the decree has been transferred to another court, to that court. This was so held in the case of Deshbandhu versus N.L. Anand, 1994, 1 SCC, page number 131. So from this, we may infer that the execution application can be filed in the court which passed that decree, or if that court does not exist, then to whom that powers of the courts has been transferred, then that transferring court is having the jurisdiction to try this execution application. Now the very important question which may come to a mind of a law student is that who may file an execution application? The answer to this question is it may be filed either by decree holder or by his legal representatives. In case his legal representative is also not available, then the representative of a person claiming under the decree holder, that is by way of assignment of decree, and thereafter any person claiming under the decree holder can also file this application, and further includes the transferee of the decree holder. So, till now, we have already dealt with the initial concept of execution and also by whom the said execution application be filed before the court of law. Now I will move further. Now again a very important question arose, that against whom this execution application may be filed. Now the answer to this question is it may be filed against judgment debtor or the legal representative of judgment debtor if the judgment debtor is dead, and also by representative of or person claiming under the judgment debtor, and it also includes the surety of the judgment debtor. Now, next question is, to whom the execution application may be filed? The answer is, the answer to this question has been given or dealt under section 38 and 39 of Code of Civil Procedure. The answer is court which passed the decree or the court to which the decree has been transferred for execution. Next. Now, what does the execution application contains? Except in the case of money decree, every application for execution shall be in writing. So from this we may infer that an oral application can't be entertained, or if entertained, then it has very limited use. and verified by the applicant or by some other person acquainted with the facts of the case. And it includes the number of the suit, name of the parties, date of the decree, and amount of the decree. So from this, we may infer that an execution application must contain the following particulars, such as number of the suit, name of the parties, date of the decree, and amount of the decree. Now the question arose over here is there any format for filing an execution application? To this, the answer is yes. There is a form, and that form is form number 6, which is given under Appendix E to the first schedule of Code of Civil Procedure. But even if an application is not in the proper format, the defect is not vital or material. Why? The defect is not vital or material because of the sole reason that procedural law has been made the handmaid of justice, as correctly laid down by Justice Krishna Iyer. Therefore, this application filing comes under the category of procedural law, which is subservient to substantial law. Therefore, to give effect to substantive law, the procedural law may be relaxed by the court in certain circumstances, and that depends upon the judicial discretion of the judge. Now I would like to move further. What is the procedure on receiving an application regarding execution of a decree? The procedure is mentioned as under. Once the application has been received by a judge, then he may either admit or reject that application. And if he admits that application, then that application can be admitted under Rule 17 of Order 21 CPC. So, in this regard, I would also like to mention that the word admission has also been defined under the Indian Evidence Act, and the relevant provisions regarding the same is given under Section 17 of the Indian Evidence Act. So from this, we may infer that this word admission has an interplay not only in the Code of Civil Procedure, but also under the Indian Evidence Act. Hence, we may conclude that there is a interconnection with regard to this provision between the Indian Evidence Act and the Code of Civil Procedure. Once the application has been admitted, then the court may, that is the executing court may give notice to the other side, thereby to give an opportunity of being heard to that particular party. And once the hearing is to be done, thereafter the court may, in certain circumstances, give notice to the other side, and that provision or the rule is Rule number 22, read with Rule number 105 and Rule number 106. What is the procedure after notice? This is all about how the application how the application regarding execution be dealt into by the court. After hearing on the notice, the court may hear the parties and decide that particular application. Now, next question is, what is the time limit for filing an execution of decree? The time limit for filing the execution of decree is 12 years. Now, the next very important point which needs to be dealt herein is that, is there any relation between the res judicata and execution? Answer is yes. The provisions of res judicata would be applicable to execution applications as well. This was added by 1976 amendment to the Code of Civil Procedure, wherein it has been provided that the provisions of the res judicata would be applicable to the execution proceedings as well. Now, the next point to be dealt here is that, what are the modes of execution? How can a decree can be enforced? The modes of execution are the delivery of the property, and thereafter it may be also by attachment and sale of the property in the hands of judgment debtor. If it is not possible, then the judgment debtor may be arrested or kept under detention, and thereafter that property would be sold by way of appointment of receiver. And also, if the aforesaid 4 points need not be dealt into, if the judgment debtor pays the decretal amount to the decree holder, so the aforesaid steps need not be taken by the court. If a requisite amount or the decretal amount is being paid to the decree holder by the judgment debtor. So this is all about today's lecture. Hope you have learned from it. Now, I would like to mention about the new topic which I am going to take in my next lecture. In my next lecture, I am going to discuss about the initial steps in the suit and also the concept of jurisdiction and place of suing. Hope you have enjoyed this lecture and have also learnt from the same. In case you have any doubt, then you can write it to me at my email ID, that is rahularora.gn@jagannath.org. Hope you have a good day ahead. Thank you very much. We'll meet you soon.